So, excellent. Welcome, everyone, as I say. So, I'm very excited to be moderating this panel. I love this topic. And we've got a really exciting panel talking about crypto fraud and asset tracing. And as I say, it's my privilege to be chairing this morning. It's going to be cracking because we've got a range of different perspectives, different views. So we have views from a claimant, we have views from a legal team, and we've got views from the investigator. So we try to cover all perspectives. And the question is, isn't it, are the courts doing enough? Are the courts doing enough here to make sure that trust is built, that integrity is built in this space? And the short answer, I would say, to that question is they are certainly doing a lot, and yes. So I'm a Brown Rudnick litigator. I've been doing fraud and asset tracing for over 30 years. As I say, I love this space in particular. I'm joined in the next 40 minutes by my fellow litigation partner, Jess Lee, who moved seats. So Jess and I have been on a lot of huge fraud cases over the years, doing lots of injunctions, but also, not to forget, there's a lot of disputes in this ecosystem, not just fraud. You know, there's, with Neil Foster, I was doing a dispute in terms of, you know, the founders, the funders, the misuse of confidential information, trade secrets, all the disputes you'd usually get, you'll have in this eco-space. On the panel, we're joined by Chloë Bell, a barrister at 3 Verulam buildings, who's waving a hand. Thank you, Chloë. Then Carmel King, who's a director at Grant Thornton. Carmel is the investigator. So Carmel, black and white, check jacket. And then very honoured to be talking, and I feel very inadequate, because Lavinia Osbourne, next to Jess, is just such a superstar in terms of her CV. She's a blockchain NFT specialist, but also has set up a charity and also is a claimant in an NFT dispute where she's made law. And then finally, having considered in the 40 minutes all the risks and the problems in this area, I didn't want to leave you with feeling doom and gloom and wanted to offer you the opportunities in this space. We're going to leave on a high note, a creative high note, before we go to coffee with Joella DeRoy, who is, amongst other things, an NFT artist who sees the opportunities in this space. So I was listening to the radio 4 this morning, and the MD of Kraken was talking about, and he said there should be a special place in hell for crypto fraudsters. And he said that they were doing more than banks, for example, in this space to build integrity and trust in this area. So, for example, if certain transactions were being flagged, they put them on hold and they made inquiries, which is good to hear. So, Jess, kick us off. Tell us briefly, what types of fraud are you seeing in this space?
I mean, I think to start off with, I think humans are generally very predictable creatures, and you know, bad actors will always develop new ways to target people and try and exploit people, and that is exactly what we're seeing in the blockchain industry. But that's not unique to the blockchain industry. And I just wanted to rewind and you know, look at how fraud has developed over the years. If you look, you know, blockchain, I think, is just another means by which fraud can be perpetrated. So, you know, taking it back to the 1920s, when you had, you know, Charles Ponzi perpetrating investment scams via mail fraud, when you look at the principles of that, it's really just a promise of large returns on an investment, when the reality is that there's nothing really there. And you look forward to crypto and blockchain scams, and it's more or less the same thing. You're looking at investment for promised large returns, and it ends up, you know, in a rug pull or, you know, a fraudulent ICO offering. There ends up being nothing there. So I think that behaviour is just being permeated again and again. And I do think, however, that there are a number of additional factors which I do think play a part in fraud in this area. So obviously we've seen from Toby's brilliant charts earlier that it's a very volatile market, which I think necessarily attracts investors that have a higher risk tolerance and risk appetite. And, you know, because of that, they may be more tempted into, you know, things that are do turn out to be fraudulent. Secondly, I think decentralization can play a part because you're taking it back to you are having control, you are taking ownership of your assets, but at the same time, you are accountable for everything. There isn't a centralized bank or authority checking or monitoring fraudulent transactions for you and flagging when things are suspicious. So it really does fall on your own shoulders. And I think lastly, it's the online world and social media. I think we're increasingly online, not least because of lockdown where there wasn't much else to do. So people are conducting their activities online. You've seen a reduction in the use of cash, probably also because of the pandemic and not just because of the new technologies that are coming through this space. But because of that, you have a much broader access, if you're a fraudster, to people all over the world. And you have the support of influencers on social media who are marketing and promoting these scams without really knowing what they are. And people are really jumping on that bandwagon thinking that crypto is this get-rich-quick sort of scheme. And unfortunately, they are falling victim to fraud.
Great. Carmel, tell us, what are you seeing as an investigator at Grant Thornton?
Thank you, Jane. For the reasons that Jess has outlined, we're seeing a lot in terms of investment scams, Ponzi schemes, romance scams, and all of those kinds of things. There's a really good speech Nick Furno from TRM Labs does called "There's no such thing as a crypto fraud," and he's absolutely right, and I recommend it to everyone. But there are things specific to this space that we're seeing more and more of. Hacks, ransomware attacks in particular, seem, to me anyway, to be on the rise, or we're certainly being referred more and more of them, and the resultant fallout, solvency issues with companies that have suffered breaches as well. A lot of that is, I think, because companies operating in this space are focusing so hard on growth and bootstrapping that they're not as cyber resilient as they should be. And so they're vulnerable to attack. And the fraudsters are legions of people pouring huge amounts of money into identifying vulnerabilities and attacking. So it's significant. We're also now, given the current market conditions and recent market conditions, seeing kind of grey areas. So shareholder disputes where one may have deliberately dissipated assets or hidden them. We're seeing, say, for example, different kinds of issuances or NFT launches that the question is, was it a rug pull, or did it fail? The community just failed to grow, and there are question marks around that and litigation around that we support. It's not representative of the industry, obviously, but the simple fact is where there's money to be made, the fraudsters will be there looking for the angles and for the loopholes.
Yeah, no, absolutely, and a good point to make that the disputes go wider than just stolen. But coming back to stolen, Lavinia, can you tell us a little bit about the NFT dispute that you're involved in? How did it happen?
Yeah, well, doing the work that I do, I've worked with a number of projects to help them promote their NFT launches. And one of the launches that I helped to promote is called Boss Beauties. It's a blue collar NFT project that promotes women. They've done really well for themselves as a NFT brand. They've worked with the New York Stock Exchange. They've done some project work with Marvel. And so off the back of the work that I did with them, they gifted me 2 NFTs. And they had, it had value. It was just before the bear, and they were sitting in my wallet. They'd been put into my wallet, and then a few months later, I was just checking my wallet as you do, and I noticed that there had been a movement. And at first, I was unsure as to what happened, and so then I had a friend and I said, can you just check this for me? And they said, yes, Lavinia, this has been moved. And I was like, oh my goodness gracious me. Now, one of the things that I do is I advocate for more women to come into this space and diversity and inclusion. And so off the back of that, I have a big network and I know a number of people, particularly in the legal field. So I was like, this is a time for me to pull on that network. And I had the honour to work with Rachel Muldoon. Some of you may have heard of her. and she represented me as my barrister. And basically, you know, the assets were removed from my wallet. And, you know, I'm quite self-aware when it comes to security and not sharing your password. And so I still don't really clearly understand how they were able to move my assets. Interestingly enough, when the incident happened, I went on to Twitter and I sent a message to OpenSea, and I'd always heard, oh, OpenSea is not very good at getting back to you. And so I got a message back and I was like, whoa, maybe it's because of who I am. And, but when I actually checked the message and the detail, it was a scammer. It wasn't OpenSea. And I just thought, are you kidding me? So yeah, so that was the situation.
And coming back to what you do, isn't it? Do you think that people are more educated now? They're more savvy, no doubt, probably as a result of the charitable enterprise cause that you're trying to make sure that people are more educated about all of these scams that are going on. Because, of course, when they're told to you, you always think, how did you fall for that?
Yeah. Well, I mean, to be quite honest, I think one of the key things that people could take away from my situation is that I do what I do. I'm very well versed in this space. So if this can happen to me, then it can happen to anyone. And I think it happening to me, it doesn't make other people feel so silly. So like, why am I so naive? It was my fault. And it's like, no, it's not your fault. There are just very intelligent people out there who are very technical and know how to manipulate the system, because I didn't fall for anything. I didn't give my details away. But to answer your question, I think people are more aware, but I don't think that they are skilled enough to protect themselves, unfortunately, because like I said, these scammers out here, they're very intelligent. We're not dealing with stupid people, and they're intentional, so they know exactly what they're doing and why they're doing it. And a lot of people in this space, they do lack the technical understanding of how a smart contract works. And even I lack that technical understanding, but I do have a premise of understanding of how it works. So,
yeah, well, thanks for sharing that with us. Difficult as that moment must have been when you discovered what had happened. And well done taking it to the courts. And I'm glad that you're getting help from the courts as you are. So Jess, tell us, how do you think that the crypto events that have been happening recently that we've been talking about has impacted on fraud in this area?
Yeah, so, I mean, obviously we've seen liquidity issues, we've seen crypto collapses, and I think that is having an impact on the fraud that we're seeing in this area. I saw some figures in Chainalysis crime report for this year, which it was looking backwards. So they found that crypto scam revenue had fallen significantly in 2022 from $10.9 billion to $5.9 billion. But actually the crypto stolen from DeFi protocols had increased slightly. So just exploring the reason for that, I think those liquidity issues, crypto collapses, have had an increase in terms of focus for the industry as to building proper risk management, corporate governance structures, and rebuilding trust in this industry. And because of that, perhaps there has been a slight fall in the fraud that we're seeing. I think the other thing is that investors are probably a little bit more cautious, a little bit more aware, less likely to click on a link that comes to them in a Discord channel saying, this is a great investment for you. And also, I think, because of that, there has been, a real move towards self-custody and decentralized exchanges and platforms. And perhaps that's why we're also seeing an uptick in fraud on this in the decentralized platform and exchanges. And I mean, that said, I don't think that decentralized platforms are immune. I mean, we've seen a flurry of recent activity there where they have been hacked or DeFi protocols have been manipulated and users' funds stolen through, flash loans or smart contract exploitations. And I think we will continue to see that. But again, that may well drive, better security, better audit of smart contracts and hopefully reduce fraud in this area.
Great. And so, Carmel, just tell us, so Jess been talking about fraud, but how are the collapses, how else are you seeing the collapses? What are their impacts?
Yeah, the collapses I'm seeing, they're exposing the fraud and the negligence at the organisations that have collapsed. So whether it is through bad acting on behalf of the directors or people in control of the organisation, or whether it's just through the focus on growth beyond all else, we're seeing, I have one where there are absolutely no records for the company other than what's happened on chain. It's an investment, it's a company that there's 70 million, I think, invested in it. They have no records of their investors. We don't know who they are, They have no records of any of the onboarding. They have no records in terms of their own finances. There's absolutely no infrastructure there, and there's no compliance either.
And no insurance?
Probably not, no. But and then, so from an investigative point, all you have, and it's decent obviously, is what's on chain. And that's how you can look at what happened in the company. But at the same time, it's very, very difficult. And we have another one, we had 12 people on secondment to another company for a year building out their finance department, because the company started off with an Excel spreadsheet worth a couple of $100,000, found itself worth many millions and still had the Excel spreadsheet and no finance or compliance team. And it took a year to build out that department and give them the support that they needed, and they're absolutely flying now. But you can just see how things move so quickly in this space, and companies grow so quickly that it's really easy to overlook the absolute basics that we take for granted in the more regulated sectors. And then when these things collapse, you do have to look at the negligence, and you do have to look at whether it was deliberate or not. Either way, there are vulnerabilities there for the people in charge.
Yeah. Chloë, do you want to just pick up briefly about greater scrutiny as a result of what's been happening?
Mic not working. So when I started work in this area as a barrister, most of my cases were a bit like Lavinia's, where there's a bad actor who's effectively stolen from you, but it just so happens that they've stolen in a pretty technical savvy way. What I think events in this space, particularly FTX and Sam Bankman-Fried and these entities and institutions that we are perceived to be legitimate and well-run organisations, what I'm starting to see as a barrister now is much greater scrutiny on the systems and the exchanges and the entities that facilitate these frauds by bad actors. So litigants are starting to look at regulatory avenues of redress in the UK. Actually, when you look at how FSMA, the Regulated Activities Order, is drafted, it's pretty broad. The FCA has said that they're a technology-neutral regulator, and that if a product resembles a traditional security, then it's within the perimeter. And so there's a lot more emphasis on actually looking at the products that are being offered by these entities and scrutinising them in terms of whether they have the relevant regulatory permissions. And I think the US is actually quite a good jurisdiction to look at, because they're some way ahead of us in terms of actually saying, yes, that is a security, and their enforcers have been a little bit more trigger happy on that front. But I do think this year and next, we'll see quite a lot of activity in the courts in terms of pushing the boundaries of our existing legislation for entities that actually probably thought when they started out that the law didn't apply to them in any way, and actually laws that we've had for many years are actually fit for purpose to regulate them.
Yeah, and indeed the MD Kraken that I heard on the radio this morning was saying how important, isn't it, that they're regulated. They want to be regulated because obviously if you want to get new money in, it's obviously important to try and have trust and integrity in the system. So Carmel, just moving us along to the initial investigation when you discover the fraud like Lavinia did. So how can what you do help on the initial discovery of what's happened, the fraud? Talk us through it.
There are a number of key things. Blockchain analytics is a significant part of it, depending on the nature of the fraud. For the last couple of years, I've been out in the market talking about it, and when I'm in front of a less sophisticated audience, that's a terrible thing to say, an audience who are less informed about this kind of space, I describe blockchain analytics as being like having all of the bank statements at once, instead of having to go through, in a traditional investigation, a rather tortuous process of court application after court application after court application for disclosure when you're following a money trail, for example. So the analytics can be really handy, particularly in situations where funds have been moved to a centralised exchange. I mean, that's just a dream in terms of getting freezing and disclosure orders and all of that kind of thing. It does get more complicated than that, and it's an art and a science at the same time. You know, it's not a case of pressing a button and then getting the outcome and something is definitively correct. And I have seen differing opinions in terms of analytics reports. The other thing is that, I mean, I do the investigations, but I'm an asset recovery expert. I'm an insolvency practitioner, and you have to have a view for the very end of it. There's no point in kicking off an investigation or litigation unless you have a view to what's going to happen at the end of it, because the whole point of it is getting back the assets or restitution for the victim of the fraud. So you have to use a range of different things. You have to use open source, you know, intelligence, human intelligence in certain circumstances, and just identify, ideally, more than one line of attack. In this space, often all you know is what's happened on chain, and it's your action will be against persons unknown, like it is with Lavinia. But in many cases that I've seen, there can be some kind of real-world nexus and some other line of attack as well.
Yeah, so talk a bit more about the sort of the corporate intelligence, the human intelligence that you're talking about, so that the more sort of traditional, I suppose, intelligence. I'm not the expert in this. Two of my colleagues are over there in the room, and they will talk you silly about corporate intelligence. But having said that, there's such a wealth of information out there. Jess has already mentioned about people living their lives online, and the number of times we found, trying to find an individual to enforce a judgment against him when we don't know where in the world he is. A very, very wealthy individual, and it turns out his idiot son, who's a DJ, is posting on social media about a visit that his parents did to Monaco or wherever, Dubai or wherever he happened to be. Birthday party, isn't it?
Yeah, exactly. And it is, there are amazing things that you can do with photos that you might not even imagine in terms of background information, the metadata in it, looking at, various tools that even Google supplies in terms of identifying locations, online registers or publicly available registers of ownership. A lot of the work I do does involve third parties holding things or complex trusts and that kind of thing, but these things can be unravelled with time and with diligence and with litigation.
Yeah, absolutely. And of course, that's where the courts, particularly in recent times, have really been able to help to compel that disclosure from third parties. But I'm getting ahead of ourselves. So Chloë, just tell us about the importance of the expert evidence needed in order to make the application to court.
Well, I think in this space, it's the key piece of evidence that you need to show to the judge in order to obtain a freezing injunction or a proprietary injunction. You need to demonstrate that the asset has moved from X to Y. And usually a diagrammatic representation is the best way of demonstrating that in this area. What I would say is that I think something that Carmel
should I just very quickly just say, freezing injunctions and proprietary injunctions, those are the ones where they just preserve the status quo, freeze assets, particularly proprietary assets, because you're saying, that's mine.
Yes, exactly.
I want it back.
To kind of stop things in their tracks until you get a decision saying, actually, you were the rightful owner of this asset and you have to give it back. But
because Lavinia, you're seeking a proprietary injunction, aren't you, for your NFTs?
I received a proprietary injunction, and as you stated, it was the first case in the world that was given that status.
Fantastic. Sorry, Chloë.
Yeah, I think what Carmel alluded to was there are varying standards that asset tracers adhere to, and I think our judges are now starting to become alive to that. Most of the injunctions in this jurisdiction were unopposed, so when a return date happens and the defendant is allowed to make submissions, often they haven't turned up. I think exchanges are now starting to dig their heels in and defendants are starting to turn up. That's when the methodologies used by asset tracers are scrutinised. So I do think it's really important that you choose a high quality tracer so that when the time comes that you have to defend the methodologies used, you've done your due diligence and you've adopted a reasonable strategy and your injunction's not going to be discharged because you've cut corners.
Yeah, no, look, I think, isn't it, as they always say, these kind of things, injunctions are nuclear weapons, and you should use them very, very carefully, and you should assume that the defendants are going to come out fighting, and so you really don't want to have a water pistol in your hand. So, absolutely. So, Jess, tell us about discovering the where, the what, the who. How can you determine what legal remedies you're going to get?
Yeah, so I think we've obviously touched on freezing and proprietary injunctions, and I think it's important to start your look at your strategy from the very outset. These assets can move very quickly at the click of the button through various different wallets, and it's important, I think, that the technology does allow you to real-time track that, which I think is a bit different sometimes to bank accounts, where it goes into another bank account and you have to go and get an order against the bank. But those existing remedies that we've been using in terms of fraud and tracing money through bank accounts, we have also been applying in the UK and in other sort of common law jurisdictions are, disclosure orders, so information orders, and freezing and proprietary injunctions. And I think there are other things in your arsenal that you should be considering at the outset. One of the things that Jane and I have done a lot of is search orders, which is, it really is the nuclear option in the UK, where you're allowed to go and essentially search someone's premises on the basis of a civil court order, which is a very draconian measure, but it is available if there is a strong prima facie case. And I could think, I could perceive instances where you might have, someone that has perpetrated a rug pull, someone that's a serial rug puller, and you know where they are, and you know that they may have cold wallet storage or computer records or files, documents, or anything like that. And you can go and get a search order to try and preserve those assets for fear of them being destroyed or moved on again. So I think it's important not just to think about the online tracing, but also traditional investigative measures like Carmel touched upon. Social media is a really good one, but also, can you go in and recover, hard copy documents or hard drives and files?
Yeah, and that's one of the purposes, isn't it, of the search orders or the delivery up orders or the imaging orders. It's obviously to preserve the assets, but actually we all know now that data is the real king, queen, and so that's a way, isn't it, to get the data, and often it's very hard for defendants to recover from it when you get those kind of nuclear legal tools. But Carmel, tell us a little bit how, as the investigator, you touched on it earlier, but just deep dive a little bit for us. How do you get around when, of course, the fraudster is covering their tracks?
I think, because it's the blockchain and it's immutable, it's an excellent resource for evidence from my perspective. There are obviously ways that fraudsters can attempt to obfuscate using mixers and tumblers and bridging and all of that kind of thing. I'm not going to sit up here and say that we can work through all of those. We can, on occasion, do it. Mixers can be unpicked. It depends on the circumstances, and it can be very expensive. So you have to weigh up the cost-benefit and whether something is even possible to proceed with. When you look at privacy coins like Monero and Zcash, again, we can deal with that depending on the circumstances of the case. This is me not promising anyone anything. I hope you can all make that out. It's important to notice that the use of Monero and Zcash is tiny in comparison to Bitcoin or ETH or something like that, for example. So there are ways of teasing that out, and then there's human error. The takedowns of the major black markets online, and a lot of the major cases you see where blockchain analytics were used as a tool, it was good to a certain point, but actually there was human error potentially going back years in terms of people posting things online, even photos, revealing their identity in their teens, or lapses in uses of privacy browsers like Tor, or a failure to use the encryption software in their correspondence. And all it takes is that one little thread to pull on, and you're away, really.
Yes, very, very happy times when you're in your office and you find that thread and you pull. Had lots of those. So, Chloë, do you want to just deep dive a bit more as to how the courts here in this jurisdiction, and I think they are doing very well, seek to stop assets being moved, but also to help get the data that you need to asset trace?
Yes, of course. So we've mentioned freezing orders and proprietary injunctions, which are to effectively stop the assets in their tracks from being moved further. A more recent case that I was involved in, we're still waiting for the transcript, but it's public, was actually an ethical hack that an entity conducted on behalf of the victim of fraud. So they'd been contacted by a white hat, informed that there was a flaw in their protocol that could be manipulated in order to gain access to a vault, it was called in that case, and then conducted the hack to put it into a special wallet where it would be held until trial. So that was quite an interesting and unusual set of circumstances. So those tools are readily available in our courts. Additional tools that you can use are known as disclosure orders, bankers' trust orders, Norwich Pharmacal orders, which normally you will seek against an exchange where Carmel says to me, this wallet that you're looking at is actually associated with Binance or Kraken. So you need to get a disclosure order against them to get some KYC information on the putative fraudster. So they are readily available. And the slight stumbling block in this area is that most of these entities are not UK entities. So you do have to get what's called permission to serve out of the jurisdiction, permission to serve the documents on an entity that's incorporated elsewhere. Our judiciary has shown a great willingness to give permission to serve out of the jurisdiction. They've recently reformed the civil procedure rules on the gateways that you need to satisfy to achieve that. But I do think there will now start to be greater scrutiny on, is England actually the proper forum in which to bring these applications, or should you actually be bringing them in the place where the entity such as Kraken or Binance is incorporated, if you can find out where that is. Yeah,
and Chloë, just skipping over service for 1 minute, but going to actually that point now, which is you don't know who to sue. So do you want to talk a little bit about the persons unknown and how the courts are actually helping in that respect? And then I'll come to Lavinia about how you use an innovative way to serve. But Chloë, with you for a minute.
Yes, so in these cases, because of the nature of the assets and the blockchain, you don't immediately know who the perpetrator is. Most people refer to it as anonymous, but I think pseudonymous is probably a better way of describing it, because they will have provided passport details or bank details to an exchange that they may be associated with. So what you can do is start your claim against persons unknown, so a category of unknown people, so long as you're able to provide the court with enough detail, whether that's a wallet address or a transaction ID, that makes the group a closed group. So long as you can do that, you can get these injunctions with a view then to further specifying and identifying the perpetrators when you've got hopefully some assistance from exchanges that they're associated with and KYC information.
Yeah, and the courts are very good, isn't it? Is actually saying, right, define your class, but
yes,
also we're going to exclude the following.
Yes, exactly.
So that actually too many people. Lavinia, just quickly talk to us about how you use service.
Mm-hmm. So because the individuals in my case are persons unknown, and it's important to say that there is a distinction between, say, a crypto asset and an NFT asset, because of course an NFT is non-fungible and it's just moving through the blockchain system. And so sometimes it can be very difficult to pick up a point where they actually entered into the blockchain system, so to speak. And so with that being the case, what we did is we served, because we didn't have an address, we didn't have an email, we didn't have a telephone number, we didn't have anything, because the person's unknown, we served by NFT. And so obviously it's quite interesting. My NFTs were stolen, served by NFT. But ultimately it was a way of getting it into their wallets, because we know those wallets have been used, and therefore if we serve the injunction into the wallet, then, because one of the other thing about wallets is that you don't have to get permission from the person who owns the wallet to airdrop into it. So you can send the paperwork to the wallet. So yeah, that's what we did.
Great. Well done. So Jess, do you want to pick up on, so question? No? Do you want to pick up on what happens when of course, now as lawyers, we follow the money or we follow where the data is. So everyone goes now to many exchanges to try and get the KYC. Do you want to, just from an exchange point of view, talk to how they respond to these knowledge pharmacals, these disclosure orders that are being served?
So I think there has been a cultural shift from when these orders were first being served. I think initially exchanges were fairly reluctant. Some of them I won't name, but some of them had taken the position that we're not in your jurisdiction, we're not subject to the UK jurisdiction, we're borderless, we're decentralised, we are not subject to any court order. And I think part of the recent market events have actually sort of helped to change that attitude. And we are now seeing exchanges operate more like banks have been in response to a fraud. If there is a court order, exchanges are much more willing to comply with that court order. And that said, I think if you are an exchange, obviously if you are based out of the jurisdiction, it is important to think about whether there are local law requirements. So if you're responding to a disclosure order, are there GDPR data privacy concerns at hand? Is the court order actually, drafted properly to seek the information which is being sought? And looking at all of those things in the round, I think there is a lot more compliance in this area. Sorry, a question over there.
Yes. Oh, just you're talking about KYC and ML, but what about just basic? In the States, if you're doing business in a state, you have to register with the state. You get a business license.
Yes.
Or you actually have to qualify to do business in the state. It's different here, but I would think, even if an exchange isn't incorporated in England or in the UK, they're still doing business here. There's still clients here, so I would think there'd be some very basic licensing, so you'd know who they are, and they'd have to comply with whatever issues that come up.
Yeah, I mean, the information orders are broad enough to capture KYC. It really depends on the facts and circumstances of the case as to what information you are seeking to obtain. But you're right, you can look at other information that is out there. And again, that said, I think the level of information that is possibly available really does vary.
They were saying we're not incorporated here, we're borderless.
Yeah. Yeah, absolutely.
So,
Whether it's qualifying for business or getting a business license, I'm just saying.
No, I follow.
So the approach that has been taken in a number of cases now is to name an entity that is registered, say in the UK, or find directors, or find a hook. But I think there has been a shift that isn't really necessary anymore. There was a recent case a few months ago where there were exchanges outside of the jurisdiction who were served with such an order, and despite one of the exchanges saying that this complying with this order would actually breach our terms of use, and another exchange saying, well, you've named the wrong entity, it's not the right entity, they've said, well, nevertheless, we'll comply with the order if it's made. So I think there has been that shift there.
Yeah, I think the courts are finding that there's been gaps and that's where, as Chloë mentioned earlier, the courts are coming in with the rules to plug the gaps so that data and trying to get data from those mixed up in frauds can't be avoided and evaded. And actually the courts are saying we'll reach overseas, albeit they're very mindful of the fact that they have to be extraterritorially sensitive to other jurisdictions as well. I'm very mindful of time. I just want just while we're with you, just talk very quickly about, of course, in every fraud, you look for where's the money. So the fraudsters may have disappeared, all of that. So other ways, talk to us about the Tulip Trading case. So where there's a developer liability issue, just very quickly, if you could.
So just running through that quickly, that Tulip Trading case is a claim brought in the English courts by Dr. Craig Wright, who claims to be Satoshi Nakamoto, the creator of Bitcoin. Now, he had around 3 billion worth of Bitcoin in a wallet at the time. It's probably worth a lot less by now. But at the time the claim was issued, it was valued, and it was around 3 billion. He had his private keys stored in an encrypted file on his computer. His computer was hacked by persons unknown. He lost access to his wallet. So he had 3 billion sitting in a wallet that he couldn't access. And so he brought a claim. He couldn't identify who the hackers were. So he looked elsewhere, and he looked at the developers of the Bitcoin network, so those that maintain the Bitcoin networks. And he brought a claim against them, saying that they owe him a fiduciary duty to essentially, those with more technical expertise will correct me if I'm wrong, but I think it would probably be a fork in the network of some sort to reroute the crypto, his stolen crypto or inaccessible crypto, back to him. And now that was it's a very sort of early stage in the proceedings, and lots of lawyers in the UK and elsewhere got very excited because the Court of Appeal handed down a judgment earlier this year where they were looking at whether the claim could proceed or not. And essentially the developer said, well, this is absolute rubbish. We cannot possibly owe any duty in these circumstances, and the claim should not proceed.
Can I just cut in there just to say that the Court of Appeal has... Let me just, Chloë, just
yes.
quickly talk, 30 seconds if you would, about, of course, one of the things, isn't it, is like banks and traditional fraud, we fraud litigators go after the banks to say, you should have, you didn't, blah, you're liable. How are you seeing that with that argument against the exchanges?
So I think it's on two premises. The first is that the exchange is what's called a constructive trustee, so that the exchange ought to have known that there were bad actors acting. There are a number of cases along those lines on foot. I personally think that avenue for redress is going to be pretty limited because in many cases exchanges act like traditional banks. They have pooling wallets, so they sweep up funds when they come into the exchange and then use them for their own transactional purposes. In those cases, the exchange is most likely going to be what's called a bona fide purchaser for value. And in those cases, then the constructive trustee argument is going to fall away. So it's only in very rare cases where the particular point in time where you catch the fraud and the exchange hasn't dissipated the assets for their own purposes that you're going to be able to use that. The other avenue of redress against exchanges is under regulatory law. So the exchange is somehow breaching FCA regulations or the perimeter. And that's kind of a line of cases where there are going to be a lot of preliminary arguments about how you litigate against exchanges in this jurisdiction where their dispute resolution clauses are pretty unfriendly to UK investors, requiring them to go to arbitration, saying that a foreign law is applicable to the dispute, saying that English courts don't have jurisdiction. So I think there'll be quite a lot of movement this year in that area as well.
Yeah, no, I think very exciting.